Thank you, Acting Speaker. I rise to speak in support of the Justice Legislation Amendment Bill 2023. As we've heard from the debate thus far, this is a wide-ranging omnibus bill that amends a number of acts to support and improve the operation of Victorian justice and legal systems. It is a bill which seeks to do a number of things, as we've heard, but I'll just run through those as quickly as I can. It seeks to amend the Court Security Act of 1980 and the Open Courts Act of 2013 to permanently embed temporary measures for remote hearings and management of court premises, which would otherwise lapse on the 26th of October 2023. The bill amends the Coroners Act of 2008 to make the coronial system more transparent by providing coroners with an explicit power to direct coronial investigators in coronial investigations. The bill amends the Spent Convictions Act of 2021 to address unintended barriers to eligibility to have convictions spent, data sharing and judgment publication. The bill amends the Firefighters Presumptive Rights Compensation and Fire Services Legislation Amendment Reform Act of 2019 and the Forest Act of 1958 to expand presumptive rights legislation to include 3 additional female-specific cancers, which we've heard just recently on from the last contributors on. The bill amends the Legal Profession Uniform Law Application Act of 2014 to clarify the application of the legal professional uniform law in Victoria and enhance protections for Victorian consumers of legal services by enabling the register of disciplinary action taken against lawyers to be updated immediately. The bill also amends the Children, Youth and Families Act of 2005 to support the rollout of the Electric Case Management System portal in the Family Division of the Children's Court. And the bill amends the Jury Directions Act of 2015 to clarify that certain jury directions are available in all sexual offence trials. The bill, Acting Speaker, makes minor and technical amendments to the Criminal Procedure Act of 2009 to allow specified employees under the Dairy Act and the Meat Industry Act to witness statements that are provided in criminal prosecution briefs. And it also amends the Victorian Civil and Administrative Tribunal Act of 98, the Wrongs Act of 1958, the Limitations Act of 1958 and the Domestic Building Contracts Act of 1995 to address various legal and procedural issues to identify certainty in respect to VCAT's jurisdiction and processes in response to recent Supreme Court decisions. And the bill also amends the Victoria Police Act of 2013. When combined, each of these reforms will help to ensure we continue to improve the operation of Victoria's justice and legal system for a modern, fair and contemporary setting. However, it's part 11 of this bill that I really would like to focus the substantive part of my contribution on, Acting Speaker. Part 11 of the bill makes changes to the Crimes Act of 1958 to ensure that the Victorian Aboriginal Legal Service, VALS, is contacted in all cases where a person taken into custody identifies as Aboriginal. This change is important to ensure that the Victorian Aboriginal Legal Service is able to provide prompt and culturally appropriate legal assistance to First Nations people who come into contact with the justice system, a key factor in tackling the overrepresentation of Aboriginal people in custody. Whenever an Aboriginal person is in custody, Victoria Police are required to notify the Victorian Aboriginal Legal Service. However, currently a notification is only required where an investigating official is of the opinion that that person is of Aboriginal descent. While an official must take any statements by the persons into account, a statement of self-identification is a consideration rather than a mandatory trigger for notification. The amendment in this bill will make sure that a statement of self-identification as an Aboriginal person always meets the threshold for mandatory notification, regardless of any other factors or opinions held by investigating officials. Investigating officials may still notify the Aboriginal Legal Service if they know or are of the opinion the person is of the First Nations community. This may be in circumstances where the person is unwilling or unable to self-identify, or, for example, if they're unwell. This amendment responds to a recommendation from the report of the Parliament's Legal and Social Issues Committee inquiry into Victoria's criminal justice system. And it is this parliamentary committee report which underpins this reform contained in this bill that I would like to draw the House's attention to. Acting Speaker, on the 3rd of June 2020, the Legislative Council resolved that the Legal and Social Issues Committee inquire into, consider and report on various issues associated with the operation of Victoria's justice system, including an analysis of factors influencing Victoria's growing remand and prison populations, strategies to reduce rates of criminal recidivism, and examination of how to ensure that judges and magistrates have appropriate knowledge and expertise when sentencing and dealing with offenders, including an understanding of recidivism and of the causes of crime. But it's section 4.3 of the report that I draw the House's attention to, and which specifically considered the experience of Aboriginal Victorians with the criminal justice system, where on page 151 of the report it states, and I quote, "Most Aboriginal Victorians never come into contact with the criminal justice system. However, those who do are more likely to have long-term and sustained contact. Aboriginal Victorians are overrepresented throughout the criminal justice system. Intergenerational trauma, culturally unresponsive institutional structures, complex disadvantage and racism all place Aboriginal people at greater risk of coming in contact with the criminal justice system or becoming the victim of a crime compared to other populations of our community. The Victorian Aboriginal Community Services Organisation explained in its submission, Acting Speaker, and I quote again, "Due to the ongoing effects of colonisation, Aboriginal people experience adverse outcomes across almost every social detriment, including lower levels of employment, reduced access to healthcare and housing, financial disadvantage, increased rates of family violence, and adverse health outcomes. This economic and social disadvantage directly contributes to the overrepresentation of Aboriginal people in Victoria's criminal justice system," end quote. And Acting Speaker, the facts and statistics set out in the inquiry's report outline these issues and challenges very, very clearly and starkly, and show that despite good faith efforts by governments of all persuasions over the many years, we still have so much more to do to support First Nations communities. And this, of course, all begins by listening and not lecturing. I refer the House to page 61 of the inquiry's report, where again I quote, "The Victorian Government and Corrections Victoria told the committee that Aboriginal Victorians continue to be overrepresented in the prison population when compared with prison rates of all other people in prison. In 2010, the imprisonment rate for Aboriginal adults was 1,106 per 100,000 Victorian Aboriginal adults. In 2020, the rate of Aboriginal adults had risen to 1,837 per 100,000 Victorian Aboriginal adults. This is contrasted with figures with the general adult imprisonment rate, which was at 107 per 100,000 of Victorian adults in 2010 and 135 per 100,000 Victorian adults in 2020. Stark indeed, Acting Speaker. Between the 30th of June 2010 and the 30th of June 2020, the number of incarcerated Aboriginal people rose by 148%. The average age of Victorian Aboriginal prisoners is 34.5 years of age, and 7% of the Aboriginal prison population were 50 years and older, a 3% growth on 2010 numbers. Between 2009 and 2019, there was also a 774% increase in the number of unsentenced Aboriginal Victorians within the prison system, totalling 48% of all Aboriginal prisoners in the 2019 year. In the Victorian prison population, Aboriginal women are also overrepresented. Data notes that in 2020, more than 1 in 10 women in prison were Aboriginal. Acting Speaker, in response to these stark figures, and as stated by the Victorian Aboriginal Legal Service submission, which is quoted in the very first page of the inquiry's report, where they say, "Given the many inquiries and royal commissions into the criminal and legal system, it seems safe to conclude that we have reached consensus. That is, we all agree that the current system and approaches are failing. To reduce offending and to lead to just outcomes, if we are serious about addressing this, we need a root and branch reform of the criminal justice and legal system." Acting Speaker, based on the evidence and submissions that were received by the committee, they put forward over 70 recommendations for reform, including Recommendation 58, which specifically called on the Victorian Government to identify and remove barriers to culturally appropriate bail processes for Aboriginal and Torres Strait Islander peoples, in particular to support the Victorian Aboriginal Legal Service to continue to facilitate the custody notification service in conjunction with increased demand, and amend the Crimes Act of 1958 to provide that an investigating official must contact the Victorian Aboriginal Legal Service in all circumstances where a person taken into custody self-identifies as an Aboriginal person. And Acting Speaker, I acknowledge and commend that this bill today goes towards fulfilling much of that recommendation. However, another key theme that emerged from the committee's report was the need to enable self-determination by First Nations communities as part of the criminal justice system to better address long-standing and systemic issues that they experience. And at the heart of the Victorian Government's approach in this regard, Acting Speaker, is the state's commitment via the Aboriginal Affairs Framework to partner with First Nations communities to improve Aboriginal justice outcomes, family and community safety, and to reduce the overrepresentation in the Victorian criminal justice system. Acting Speaker, the Victorian Government's approach essentially is to listen and to partner with First Nations communities on issues that impact them deeply. And Acting Speaker, while at the state level we continue to do more in partnership with the Aboriginal community to address these long-standing issues, there is also so much more we can do at the national level. That is why the proposal to recognise Aboriginal and Torres Strait Islander people as the traditional custodians of their land by enshrining a voice to Parliament in the Constitution is so critical. Victoria has been the first jurisdiction in the nation to action, voice, treaty and truth, all three elements of the Uluru Statement from the Heart in 2017. We have long been guided by the principle of self-determination in our work with First Nations people, and will continue to work in partnership to deliver on these elements. That's why I'll be voting yes at the upcoming referendum, Acting Speaker, because it's time we listen to First Nations people about the issues that directly impact them. I commend the bill to the House in that regard.